I am Navleen Multani, Associate Professor in English at Jagat Guru Nanak Dev Punjab State Open University, Patiala. This lecture focuses on the constructive role of dissent in developing law. The word dissent is used to represent a variety of opinions. It includes dissent of judges for expressing views contrary to that of the majority, dissent in the case of protesters voices opposition to authority publicly. Many a times, protest rallies characterize civil rights and expression of freedom of conscience. Dissent, we can say, is a disagreement, minority opinion, and criticism of the established opinion. It manifests in multiple ways. Institutionalized dissent may be in the form of writing dissenting legal opinions or voicing disagreement with the legislative or parliamentary policies. Quasi-institutionalized dissent is evident in the role of media, the fourth estate that protects constitutional rights. Private citizens and individuals dissent through civil disobedience, speeches and protests. Dissent is related to many D words like dialogue, deliberation, disobedience, disallegiance and defiance. Dissent embraces non-violent, morally justifiable conduct. Discussion, disagreement and engaging in dialogue to reach a consensus are the main components of democracy. Non-violent dissent needs a high number of participants to exert significant pressure. The origins of law, beginning from the Athenian city-state in Greece and Roman republics in the medieval times, cities reveal remarkable evolution of law. The institutionalization of law gives rise to consensus, contestation and dissensus. Consensus, dissensus and contestation explore various dimensions of law. In order to understand the foundational framework of civic well-being and development of law, the positive and constructive comprehension of dissent is necessary. Dissent plays a pivotal role in reforming laws and addresses concerns about fairness, equity and justice. This lecture will enhance your understanding about dissent, democracy, justice and development of law. Let us first focus on dissent in law. Keeping in view the significance of dissent in writing of judgments, I will expand upon articulation of differences by the judges. You all know that judges decide cases by applying rules to facts. They act consistently and articulate differences among cases to justify the relevant outcomes. The judge cannot decide two cases alike, as different cases might require a different articulation. John Rawls, the famous philosopher, observes that every case demands public deliberation and forces the judge to justify the distinctions between persons and principles. These purposes are fundamentally contestable, and one cannot decide animating purpose of a rule without taking sides or other perspectives while assessing a particular case. There cannot be infallible fact finders and infallible interpreters in the process of decision making. So, this gives rise to a possibility of disagreement or dissent. Laws cannot be applied to all people in all places and at all times, as they operate by creating a class of subjects. These classes are then defined in a manner to conform with the basic rule of justice. Whether a law is clear, has reasonable expectations, or relies on interest so as to satisfy requirements of the public, laws are contested and the debate leads to disagreement of the norm. Laws change periodically. Public deliberation on rule of law enable revisiting to the origin of the concept. Deliberation consists of careful examination of evidence, shifting of explanatory theories, comparison and contrast of views with regard to principles and values. Dissent becomes concomitant of deliberative process based on reason in a pluralistic universe. Dissent is inevitable in a pluralistic world. Conflicting views are an ineradicable feature of the decision-making process. The practice of dissent entails the essence of reason and not of tension. To conceptualize truth and knowledge in a unitary and rational manner, vigorous deliberations for identification and assessment are required to resolve upon the right answer. Effective group deliberation is often impeded by group dynamics of polarization or group thinking, self-silencing and overconfidence. The group dynamics may lead to deliberations that are inaccurate, extreme and unreasonable. An effective deliberation is obstructed when individual is not allowed to express his knowledge freely. The product of dynamics of groupthink debilitates and minimizes the importance of counter arguments and disagreement. The best way to counter such defects is through cultivation of counter arguments and alternatives. It is only in the Platonic philosopher King's word that ultimate truth is ordained without deliberation. We must understand that rational decision making on complex topics requires vigorous discussion, debate and disagreement. Therefore, it is important to cultivate a culture of dissent and disagreement. Dissent inevitably embraces unitary or pluralistic epistemology. Dissent preserves and continues the rational debate of fundamental principles. Even in the universe where there might seem to be only one correct or right answer, right answers must be found, as they are never self-declaring. They have to be justified as right against the most threatening challenges so that these be recognized as truly right. Dissent forces reason into the open, creates a context, exposes and preserves the meaning of justice as well as externalizes the dynamics of law. The legal dimensions of dissent are validated as citizens have liberty of thought, expression, belief, faith and worship. Article 19(1) enshrines the freedom of speech and expression, assembly and association. These constitutional provisions form the backbone of citizens' right to disagree and question government actions. Various landmark judgments by the Supreme Court of India have underscored the significance of dissent. The cases of ADM Jabalpur versus Shivkant Shukla, where Justice H.R. Khanna's dissenting opinion championed individual rights even during the emergency. Another case was the Puttaswamy judgment, which affirmed that fundamental rights must be protected from government overreach. After having discussed dissent and law, we need to understand democracy and dissent. The right to dissent is the essence of democracy. The will to dissent is an effective safeguard against judicial lethargy, and the effect of dissent is actually the essence of progress. Justice Carter states that freedom of speech safeguards individuals and is an essential element of democracy. This applies equally to an average citizen and a dissenting judge. An expression of freedom with respect to social, economic, political philosophy of minority differs from that held by majority in any court and promotes democracy. The conflicting views of court members have been indispensable for freedom of expression. The law reconciles divergent rights of individuals and groups. Justice Douglas of the United States writes that law is not what it has been or is. Law is lawyers' sense of prediction. When constitutional questions emerge, uncertainty increases. Lawyers, he says, continue the uncertain search for certainty of law to find strength and glory in it. Disagreement among judges in such unpredictable conditions becomes true character of democracy and freedom of speech. As the Constitution cannot be encrusted with narrow, dominant, legalistic notions of a generation, dissenting opinions pave way for democratic processes. Dissenting opinions forecast future, look forward and not back or immediate present. The dissenting opinions stall reactionary tendencies for elevating morals and public welfare. There is also a great relationship between the rule of law and the right to dissent. So, I am going to focus on it now. Rule of law and right to dissent are both celebrated and frequently invoked for values. Consensus is a formal characteristic of rule of law that primarily focuses on properties of governance by law and the legality principle. On the contrary, many reject rule of law as they give equal importance to private property or basic human rights. A basic bundle of legal principles confuses different types of political goods and morality. The rule of law does not only encompass entire spectrum of civil and political rights, but also demands respect for and adherence to the core values beyond the formalistic properties of legality. Between the two contrary positions, an intersection of formalist and substantive approaches provides overlapping principles that are necessary for respecting rule of law as well as respecting the practice of dissent. The intersection constitutes a richer palette of essential attributes and overlapping principles which make toleration the most telling signpost of the rule of law. The common notion, formal legality and rational debate practices presuppose the possibility of a dissent. These principles also presuppose the existence of a rational disagreement. Therefore, the rule of law is grounded in a fundamentally pluralistic conception of legal and moral truth that recognizes and celebrates multiplicity of perspective and legal interpretations. According to Frank Pascal, the formalistic approach emphasizes rule and the legal process emphasizes law as its component. The social institution of law is embedded in traditions, political systems, rights which have to be taken care of while explaining for decisions. Ever since the Greeks introduced the concepts about the rule of law, a strain of formalism runs from Frederick Warren Hayek to Joseph Raz. According to Hayek, the ideal rule which is fixed makes us foresee with certainty the way authority will wield powers. Raz takes up Hayek's approach and contrasts it with a set of political and civil rights. According to Raz, rule of law cannot be equated with justice, democracy, equality, and dignity of man. He believes that there is a probability of undemocratic and unjust political systems adhering to the rule of law. Despite this adherence, there might be a gross violation of human rights. Raz expands on the limited formalistic conception of rule of law and identifies 5 principles. Government is ruled by law if laws are clear, stable, publicly available, conform to the journal standards, and are applied prospectively and not retroactively. He believes in set of virtues which cannot be captured by the phrase rule of law. Dworkin, a substantivist, recognizes individual rights. He observes the rule of law is the ideal of rule with public conception of individual rights. The rule book must capture ideal of law and enforce moral rights. Respect for human liberty and autonomy is essential to curtail any tyranny perpetrated by valorization of law. Let us just now explore the relationship between the judges and dissent. Dissent allows judges to express disagreement and serves as a beneficial outlet valve, allowing judges to satisfy their conscience on significant issues of jurisprudence. Dissent speaks to the intelligence of a future day for new understanding of the law. Hence, dissent has a vital role in the judicial system, which is of contributing to the continuing development of law. Judicial dissent enables courts to express the values of deliberative democracy. By doing so, it contributes to the larger public discussions on constitutional and legal outcomes. Dissenting opinions might also contribute to confusion and uncertainty in law and could perhaps lead to delegitimization of the court's outcome. It is largely for reasons of certainty and legitimacy that most continental European states traditionally shun the practice of dissent, though today this prohibition no longer exists in most of the European constitutional courts. Ultimately, the normative value of dissent, particularly in a democratic society, could hinge on how dissent is used by the judges who hold that power. Dissent reveals judicial decisions as the product of genuine reasoning and debate on merits. Dissent's Justice Scalia aptly comments, augment rather than diminish the prestige of the court. He explains, When history demonstrates that one of the court's decisions has been a truly horrendous mistake, it is comforting to look back and realize that at least some of the justices saw the danger clearly and gave voice, often eloquent voice, to their concern. After having understood the relationship of dissent with law, democracy, and judges, we need to understand that there is a voice and vision that is attached to dissent. So, after having learnt about all this, we gain understanding about the relationship between voice and vision. A reading of Aristotle's Politics reveals that human beings speak through the logos and conceptualize matters of justice that are shared with the world. Contrastively, animals issue sounds, cries, groans, moans, yelps that inform us about the state of hunger, joy, pain, which may be noted or ignored. Animals cannot compel us to heed to their claims. This comparison between the human and the animal world brings out the distinction that points to the distinction between those that one sees or does not. This lack of seeing does not render the speech of the latter to silence. Rather, it invokes something that approximates howls, groans, or noise. The French philosopher Jacques Rancière expands on the link between voice, dissensus, and vision. According to Rancière, there is a connection between voice and vision. According to Jacques Rancière, there is a connection between voice and vision. He flags through such metaphors a socially thick phenomenology of reception through which some agents are recognized as genuine speakers, those whose claims may be contested or denied but must be answered, and such answers justified on the basis of shared normative principles, and others are not. He writes that social space is divided into two categories: those that one sees and those that one does not see, those who have a logos, memorial speech, an account to be kept up, and those who have no logos, those who really speak, and those whose voice merely mimics the articulate voice to express pleasure and pain. Politics exists because the logos is never simply speech, because it is always indissolubly the account that is made of the speech, the account by which a sonorous emission is understood as speech, whereas some other emission is merely perceived as a noise signaling pleasure or pain, consent or revolt. Rancière rejects the logic of consensus because it eliminates every interval of appearance, of subjectification and of dispute, which is essential for creating equality. He advances the logic of dissensus because it makes the powerlessness of the excluded emerge as a political force through disagreement. Politics begins for Rancière with the emergence of the people as active agents within the Greek city-state when they demand to be included and equally be heard in the public sphere along with the oligarchy and aristocracy. Putting it in simple words, when the common people or the demos, plebeians, are not given any share in the communal distribution of the sensible, they protest against the prevailing arrangements. Their suffering makes them protest, and this ruptures the logic of archy, which is the logic of ruling. Rancière, in his book Disagreement, Politics and Philosophy, writes, "Disagreement is not the conflict between one who says white and other who says black. It is the conflict between one who says white and another who also says white but does not understand the same thing by it, or does not understand what the other is saying, the same thing in the name of whiteness. Disagreement, he believes, occurs when the interlocutors may comprehend or not understand the same thing in the same words. This can neither be a misconstruction that calls for additional knowledge, nor a misunderstanding that requires refining of words. For Rancière, disagreement inscribes resistance in politics as well as literature, which is concerned not with the words alone, but with the situation of speaking parties too. A wrong, according to Rancière, is a fundamental blabberon, noise that interrupts the order and generates resistance, as those who have no part in the natural order of domination interrupt it to create a disorder of revolt. A common wrong often creates a conflict. This conflict brings about a disagreement that seeks the equality of all speaking beings. It is because of the inequality between the parts and the non-parts, whose sum never equals the whole, that a wrong appears to be a contradiction. So, we can conclude that justice is instrumental for economic growth and development of civic well-being of society. Therefore, judicial reforms achieved through dissenting opinions promote justice. As development is an interdisciplinary enterprise, integration and repositioning of notions on justice and law are necessary for enhancing good governance. Dissents leading to legal reforms promote humanity and embody an ordered community governed by the rule of law. The notion of rightness is built on law, ethics, and fairness to fortify civic well-being. For any ills of political life, democratic theorists increasingly present discourse as the talking cure. The eruption of suppressed speech serves therapeutic ends to reveal a truth buried by the hegemonic narratives and social histories. I conclude with Charles Evans Hughes' words, who remarks that dissent in court is an appeal to spirit of law, intelligence and justice. It corrects error and possibly provides justice. Thank you very much.